Hi, my name is Chris Duren, and I'm an attorney in Wisconsin who's had his own law practice for the last 18 years. Today I'm going to discuss a legal topic with you. Please keep in mind that I'm just going to give you a very brief oversight of the legal topic. What I'm going to talk about today is not legal advice and does not create an attorney-client relationship. It is my strong advice that if you do have a legal issue or questions, that you consult directly with an attorney. The next topic I'm going to talk about today is the process of filing for divorce in the state of Wisconsin. I'm going to give you just a very brief overview of the process. In the state of Wisconsin, every divorce starts with either a joint petition or a summons and petition that is filed with the court. The difference between the two is a joint petition is where both spouses sign the joint petition and that document's filed with the court. The summons and petition is different in that only one spouse signs the petition, and then that summons and petition is served on the other spouse. And then that service is usually accomplished one of two ways, either by personal service, and that's usually done by either a private process server or the local sheriff where the spouse lives, or it can be done through what's called an admission of service, where the summons and petition is given to the other spouse, and that spouse signs an admission of service, and then that's deemed service on that spouse. In Wisconsin, you could, as soon as you can get divorced is 120 days. But when that 120 days starts depends on what kind of petition is filed with the court. In a joint petition case, the 120 days begins on the date that the joint petition is filed. If you did a summons and petition, the 120 days starts on the date that the summons and petition is served on the other spouse, and that could be either done through service through a process server or sheriff, or when they sign that admission of service. While the 120 days is going on, in my experience, most divorces end with what's called a marital settlement agreement, and that's in probably 95% of the cases I've been involved in, or in that the divorce ends with a marital settlement agreement. And that the marital settlement agreement is a document. Usually it's, it can range between a few pages to, up to 15 pages. It really depends on how detailed you want to be. But that's the document that spells out the agreement between the spouses, and is signed by both spouses. That document is going to spell out how the assets and debts are divided. It's going to spell out, who's staying in the house, what's happening to the house, who's getting what vehicles. If you have children, it's going to spell out what is the custody and placement agreement regarding the children, how are variable expenses going to be handled, is there going to be child support, if so, how much, how are taxes going to be handled each year. I'm not going to go into all the issues that are covered in marital settlement agreement, but those are some of the main issues. And that's how most divorces end, with a marital settlement agreement. And once that document is entered into by the spouses, that document is filed with the court, and then after that, assuming the court has the rest of the documentation that they need for the final hearing, after the court has that document, then the court will schedule a final hearing. Now, like I said, 120 days is as soon as you can get divorced. And that's assuming you have that marital settlement agreement in place. Sometimes the spouses don't agree, or sometimes they agree on some issues but not all of them, and sometimes the parties enter into a partial marital settlement agreement where they agree on some issues and some issues are not agreed upon, or the spouses don't agree on anything. They don't enter into any kind of agreements. In that situation, that's where the parties are, in those situations, most times the process does not end with 120 days. The parties will oftentimes be referred first to mediation. I'm just going to talk about the financial disputes. The parties would first be referred to financial mediation most times. If the parties can't resolve the issue at financial mediation, and they still can't come to an agreement, then the court will eventually schedule a final hearing and decide the issues that are being contested on for the financial issues. When there's any contested issues regarding children, that's a different procedure, and I'm just going to talk about Dane County, Wisconsin. Dane County, Wisconsin, if the parties do not agree, are not able to agree on the issues of, for example, child placement and custody, then the process is that they're first going to refer the parties to mediation. Normally, like I said, everything I'm giving you is a brief overview. There's always exceptions, but they're going to first refer the parties to mediation. If that's unsuccessful, then the next process normally is that the court will have a family placement study done. The court could also appoint a guardian ad litem for the children, and a guardian ad litem is an attorney that's appointed by the court to represent the best interests of the children. And the guardian ad litem could be appointed at the same time as the family as the family court study, or the guardian ad litem could be appointed later. If after the family court study comes in and the guardian ad litem's recommendation comes in, the spouses still can't agree on placement and custody, then the court will again schedule a final hearing on those issues. And my experience is that when there are any kind of placement or custody disputes, the divorce lasts a lot longer than 120 days. But that is the Wisconsin divorce process in a very brief overview and a very brief nutshell. But again, if you are going through a divorce, and you have any, whether it's you're having issues regarding disputes regarding finances or placement or custody of your children, or even if you're not having, even if you and your spouse are agreeing on everything, it's my strong advice to always consult an attorney, because I think an attorney is going to help you address issues that and provide that expertise that you're not going to be able to do on your own. So it's my strong advice to always consult an attorney whenever going through a divorce.